53 Trupia versus Lake George. Counselor, would you like any rebuttal time?
3 minutes, please, Your Honor.
3 minutes. Go ahead.
Thank you. I'm here today with Carla Williams-Bittner, who's worked on this case from the very beginning with me and is here to observe the argument and hopefully help me as much as she can.
Okay.
This is a case that involves the scope of the duty of care owed by a defendant to a plaintiff who is involved in horseplay. More specifically, I think the question is whether, in this case, the plaintiff's voluntary assumption of the risk, and the risk was inherent, and it was an elevated degree of danger risk.
This is a child, right? A child.
This is a child who's 2 days from his 12th birthday.
In a school.
In a school. However, in terms of the school, this is a summertime program.
Summer school. Program.
It's not mandatory. It's a voluntary program.
Okay. But in a situation where he wasn't being supervised, where he had been let out of the classroom and go play and reconvene later.
It wasn't quite that broad. He was let out of the classroom during a break between the 2 morning sessions, told to use the bathroom or the water fountain that was in the hallway outside the school.
But are you really saying that he assumed the risk of negligent supervision?
No, I'm saying he assumed the risk of falling off the banister and receiving injury.
But isn't this primarily a negligent supervision case?
It is.
That's the main negligence claimed. Can a child say to an adult, oh, I know you're supposed to supervise me, but I'll assume that risk. It's all right. I'll take the chances of not being supervised. Does that make any sense?
It does in the context of this Court's prior decisions. Putting aside the child issue for a second, and let me come back to that.
Isn't it all about the child issue?
Well, I think that question...
If you don't have a child, you don't have a negligent supervision case.
Sure you do. I mean, there are negligent... This case, in part of the Morgan case, Beck was a negligent supervision case. In the Marcano case, which was just a slip opinion from you folks, that was a negligent supervision case. I think to a certain extent Benitez was a negligent supervision case. And I think as...
Who was negligently supervised in Morgan?
In Morgan, it was one of the karate kids.
Okay.
All right. It was in the karate class. And I think it was Beck. I think it was that aspect of it where it was raised in that case.
But in the karate class, he's involved in a recreational and athletic, sports activity.
Right. But right now we're talking about negligent supervision. And I don't think you can separate a voluntary summer school program. I mean, if this had occurred, I think, during the course of a situation when school was in session, the child was required to be there.
All right, so what if there's a kid in the same class who has to be in summer school because he was left back? He failed the course and he has to go to summer school in order to be promoted. That child would be treated differently than the child here who was there voluntarily?
I would think so. I think that's the same. I think the analogy is closer than the Beck case in the karate school. The analogy is closer to that. This particular, let's assume for a second that
I'm trying to understand. Are you saying there was no instructional activity going on?
No, there was instructional activity. But let's assume it didn't happen in the school.
How is it not a regular school function then?
It was the same kind of a summer program as a sports camp, as arts and crafts, as remediation, as enrichment.
It was orientation for middle school, right?
It was
or orientation for something, right?
It was a program called Jump Start that the elementary school recommended that certain students...
So the child assumes the risk because they voluntarily go into this program? That's a distinction which makes any sense to you?
No, the child assumed the risk.
Why? Yeah.
The child assumed the risk because he climbed on the banister, slid down, knowing that he could fall off. But he's a child, isn't he? Correct. And
aren't they, by their nature, children act impulsively, children often act with bad judgment? Do we leave the child unprotected in a negligent supervision motif? Does that make any sense? That the child takes it upon himself? Could that seriously be your argument?
It is seriously my argument. And let me, if I could...
How so?
If I could proceed just for a couple seconds without being interrupted, I think I might be able to explain that. And the first issue is the in the Fourth Department, there is a case that, and it's the Lamandia Kochi case, where a 13-year-old, a year older than this child, a year and 2 days older than this child potentially, was sliding down a banister in a non-school situation where the doctrine of assumption of the risk was applied. There is another case.
Was negligent supervision at issue in that case?
It was. There was a question of the condition of the banister and negligence.
But that's really what's troubling some of us. I mean, if you're arguing that there are other theories of liability in the complaint, which there are,
right,
then I could maybe see the point. But if you're seriously saying that the child can assume the risk of negligent supervision, it's hard to see how that's logical.
And let me, again, if I can address that.
Your Fourth Department case was a residence, was a wooden handrail adjacent to porch steps of a residence. It wasn't in a school building.
Correct. But I'm saying that the duty of the school during these voluntary summer programs should be no different than the duty of the karate school or no duty than a home. These programs could have been provided elsewhere. They didn't, someone could provide an enrichment or a remediation program. Various companies do that from time to time for students in summer. They go to summer school that doesn't involve schools.
It seems to me that the where of this is or is not important. But, I mean, if he was in a football camp, if he was in a hockey camp at the school or whatever, there's a break. Right. They take the break and they go off and do stuff. And you're saying when they're off doing stuff, the stuff he did was slide down a banister, and that separate, distinct act was an assumption of the risk on his part.
That's
separate
right.
and apart from supervision or anything else.
That's right. And if I may, and again, this is the First Department case that, Judge Lippman, you wrote the decision in, and it was a negligent supervision with respect to the baseball throwing the bat case.
I remember it. Yep.
That baseball case. Your comment with respect to negligent supervision there was that negligent supervision remains a viable theory only insofar as the risk for the plaintiff, that's my quotes, only insofar as the risk upon which the action is based has not been assumed. End of quote from that decision. And in this case, what we're saying is that
this is a very different context.
Go ahead. It is. What we're saying is that the risk that this child assumed was the risk of sliding down the banister and falling off, and that once that risk upon which the action is based has not been assumed, then negligent supervision is not the issue.
So in other words, saying that the child was 8 to the child was 6.
I think that goes to the voluntariness and the knowledge. Those are issues that this case comes to you in the context of not summary judgment or trial, but it comes to you in the context of a motion to amend the answer.
Right.
I think the development of those issues, the voluntariness of it, the knowledge of the child, his ability to understand the risk, is a separate issue than the issue which is before you from the Third Department, which is
what exactly
should
is
it
the
be
risk?
recreation or not?
You're saying the risk. You're saying he could understand the risk of sliding down the banister.
Right.
Are you also saying, but could he understand? Isn't the precise risk we're talking about here the risk of being left with nobody watching him? And isn't that a risk that, by its nature, you can't expect a child to understand?
I think if you define the risk, if you define the question like that, and if you define the risk assumed as being the risk of assuming negligent supervision, then I think in any case involving negligent supervision, you could not have summary judgment based on primary assumption of the risk. Because I don't think there's anyone who assumes that you're going to have negligent supervision. And the cases are all over the lot on negligent supervision.
Well, I'm sure there are quite a lot of 12-year-olds who would be delighted to waive their right to be supervised.
I know quite a lot of 30-year-olds who would waive their right.
Yeah, but the whole point is they wouldn't need supervision if they were capable of making that judgment.
That's correct.
The theory of assumption of risk is a judgment by the plaintiff, okay, I'll take my chances.
Right.
How can you say when you're suing someone for negligent supervision, or you can't sue me because you decided to take your chances?
I think if you're going to draw the line and say negligent supervision cases are not susceptible to defense by assumption of the risk.
That is what I'm suggesting.
All right. That's not a line that has been drawn anywhere in the case law explicitly by any of the departments.
We had a case, I forget the name of it, I don't know if you cited, involving, I think, two 10-year-olds playing golf, and one of them whacked the other one with a golf club, and we said there was assumption of risk.
Yeah.
Now, that's an odd case, the way we're talking here, because
Right.
obviously, should you be leaving 10-year-olds out, playing golf? I mean, I don't know.
But I think let's change it to a 17 or a 17-year-old. And in that situation, if you have a 17-year-old, do you have the same rule with respect to negligent supervision that you would with a younger child? And that goes to the question that is already in the law, the way these questions are analyzed, and that is, was it voluntary? Did he have the knowledge to assume the risk? And that question is with respect to each individual child and is not part of this record, unfortunately.
Do you, I mean, the complaint does say, it isn't just a negligent supervision complaint, it says they didn't maintain the banister, there were design flaws, there were maintenance flaws, you name it, we got it. Do you rely on that as part of your case now? Or should we treat this just as a negligent supervision case?
I'm the defendant.
Okay.
Okay? We're the school district.
Okay. I understand. Good point. Do you
Finally.
do you make the argument that even if the defense isn't good as to negligent supervision, we should leave it in because there are these other theories? Are these other theories effectively out of the case by now?
I think for the most part, and I think that's a question better directed to the plaintiff, we are treating this as a negligent supervision case.
So if they'll drop all their other claims, you'll drop your defense too. Fair point.
And I think the negligent supervision issue is a very muddy issue. I don't think it's ever been articulated clearly in the appellate divisions. But I don't.
And up here, what's the law? We've never.
And you never have either, right?
Right. We've never allowed this kind of situation.
And I don't think it should be the negligent supervision issue should be lumped together with the voluntariness and the knowledge of the minor.
Well, even
those are separate issues.
Even considering the status as a minor, have we ever extended that elimination of duty or that adjustment in the landowner or the school duty outside the recreational or sporting arena?
Outside the recreational, in this court, no. No, this court has not.
So it would be an expansion at least of precedent as far as our court is concerned.
Yes. There are two issues. Again, outside the sports and recreation issue is one potential expansion, and the negligent supervision issue is a second. I mean, those are actually two separate issues, not necessarily one.
Thank you. Counsel.
May it please the Court. My name is Peter Ledwith. I represent the plaintiff in this case and the respondent here. This is Tom Atkinson, my partner, my son-in-law, my pal. It almost seems to me that we are dealing with a counsel for the school district for whom I have the greatest respect and affection. Is totally missing the point that this court has to look at. And this is truly a question of what is the public policy and what should be the public policy.
Do you agree that this is totally a negligent supervision case?
It is mainly a negligent supervision case.
But you haven't abandoned your claims that they failed to mop the floor or whatever.
Yeah, or to maintain
to maintain the banister
on the handrail and the
they should have. You have not abandoned those claims.
Not at all, no.
I mean, I guess I can understand why you don't think assumption of risk is a defense to negligent supervision, but why isn't, if he's sliding down a banister and it's a risk that a 12-year-old could perceive, and 12-year-olds can perceive, so why is he in a different situation from a participant in a sporting event who gets on a bobsled and slides down a slope? What's the difference?
Because we're in two entirely different worlds, Judge. Total different worlds. No,
Why?
Well, actually, jumping far ahead of what I intended to say, but I'll have to get into it then, if I may, from start to finish. Talking about the Trupia young man, here he is. He's one of a bunch of kids who are in this Head Start program. They just left grammar school. It's now July 2nd. They're in for the first day of their life, in the junior high school. This is now the big time. It's exciting. It's the middle of the summer. They've had 1 hour of class, and they're now let out into the hallway. Now, the teachers and the school district is now in a position of in loco parentis at this point. They have to be what reasonable parents would do under the same circumstances. The two teachers let these kids out into the hall and let them pretty much roam. There were one instruction and one guidance.
Okay, assuming that's negligent, I don't have a lot of problem with the idea that that's not a risk that can be assumed. But why? What about the maintenance?
You want to talk about the maintenance?
Well, yeah. I mean, I guess maybe I'm presumptuous. What I'm saying is I appreciate the strength of your argument if this is just a negligent supervision case. But if it's more than a negligent supervision case, then I need help.
Okay, well then, you don't need help. This is primarily a negligent supervision case. That's the way it's going to be presented by the plaintiff to the jury.
Isn't primary assumption of risk an absolute defense?
I beg your pardon?
Isn't primary assumption of risk an absolute defense?
Yeah, it is. I'd like to talk about that for a moment, if I may. What's going on before this court is a major request of this court to make a pronouncement as to what is the public policy of the state of New York on the comparative negligence. And to define it a little differently, you're being asked to define that line under which the defendant's negligence in creating a dangerous condition or causing a personal injury to somebody means nothing. That's the real key here. Not only for this case, but for the entire state of New York. This is a major.
There are cases in which it does mean nothing, aren't there?
There are some, but they're very limited, and this court cut those.
Well, the bobsled is one.
Yeah, well, that goes into the sporting arena. Yeah.
Mm-hmm. What's the difference between sliding down the banister and a sport? Forget about the fact that it's a kid. Suppose an adult decides to slide down the banister. Well, why is that any different from sliding down the bobsled run?
It's when and how he was sliding down the banister that is of the most significant importance. And that was as a kid, full of energy, full of bursting with, and boys and girls, 11, 12 years of age. You know the kids are going to misbehave. You know there's going to be horseplay, put it that way. Depending upon the nature of the kids themselves, there's going to be different kinds of horseplay.
Are you really saying that a primary assumption of risk is a doctrine that's just inapplicable to child plaintiffs and that's all there is to it?
It's inapplicable to a lot more than that. That's what I was trying to get at.
Well, stick to that for the moment. Is that the case that a 12-year-old who joins the baseball team or the football team or the wrestling team doesn't assume any risks?
All right. Put all that stuff to one side, because that really is all irrelevant to the issue in this case.
Well, no, but we're trying to understand the scope of the rule that you're proposing, and I'm very unclear as to whether you're saying in a negligent supervision context, in a sporting context, that you would also not apply primary assumption of the risk?
Well, if you want to hear my views on it, it is that 1411 of the CPLR is what the public policy of the state of New York is. And if we look at that statute, what we see is any case where there's culpable conduct.
So the answer is yes.
No. I'm getting towards the answer. I have to sort of explain where we're going. This court has cut out 3 types of exceptions to that rule. The first case was that Abergast case where the teacher was on a donkey. There, you have to be that decision. This court labored and pained not to abuse Section 1411, saying that that is the public policy of our state. We're cutting an exception out because it was a contract. This lady signed an agreement.
But she was an adult.
She was an adult.
I'm trying to figure out how you're applying your rule to persons under 18.
Well, okay. I'm sort of trying to get to the jurisprudential background, but I hear what you're saying. A child.
I guess to make it easy, if I have a 14-year-old who's been playing soccer since they were 6, and they fall on the soccer field, and their parents bring a lawsuit and claim negligent supervision, are you saying primary assumption of the risk cannot be asserted in that case, or it can?
I would say that if I were the trial judge and I was asked to charge primary assumption of risk, I would not. I would say this kid's just too darn young. He's not a professional athlete like the Trupia case. He's not a professional athlete like Gary Maddox was, which is the only 2 times this court talked about the sports element in the case, where they said that primary assumption, they said that comparative negligence does apply, but here the player, by his own deliberate actions, knowing every single possible conceivable danger of the sport, went into the sport a professional athlete and engaged in the activity. And in that case, it was he who said that defendant's negligence doesn't apply to me because I'm going in there and I'm going to play my sport. And the court even said, this court said, it's not an absolute bar. That was the first time the court got into sports. Then we get into the Benitez case where there was a star football player who was pushed beyond the level, at least they claimed, of exhaustion. And the coach put him back in the game anyway to play. And he got hurt. There, this court said, we're going to apply assumption of the risk here because we wish to facilitate open and vigorous, energetic performance of athletic activities by kids. But this is a kid in a contact sport, a football game where there's nothing but collisions left and right in every single play. Now, that's the two areas that this court touched on. The third area, of course, is the I forget what it's called. But there are two major areas that this court has cut out exceptions. And those are the only exceptions that this court ever cut out. Now, what the counsel is saying in this case is that here we have a situation where there's these young children, and because they were let out into a hallway by themselves where there was no supervision whatsoever, knowing full well, as parents would know, I would know, you would know if you raised a kid, that you leave 11-year-old, 12-year-old boys out in the corridor under these circumstances, there's going to be horsing around. You just know it. And they're in loco parentis. They ignored their responsibility. And what happened when they went out there? There's boys and girls. They went running up the stairs. The art room was closed. They're coming down. Our guy slides down the banister, falls down and gets hurt. The defendant in this case is saying the principles of the Torcott case, the professional athlete case, should apply to this case.
There's more than professional athletes. I mean, there's a lot of amateur sports and there's a lot of student sports where you assume the risk.
Well, this court didn't talk about it yet. That's what I'm getting at.
But if we assume the same situation in this case, except instead of sliding down a banister, these guys had decided they're going to play dodgeball, and he got whacked in the head while they were playing dodgeball, would you say that's not an assumption of this case?
It's so hard to even talk about that because it's so remotely, it's not even close to what would.
Well, it seems to me that you're saying no. I mean, if they were playing baseball and you got hit in the eye with a baseball, that's not an assumption of risk because he's a kid and there's an in loco parentis.
Well, it depends upon the age of the kid, the experience in playing the sport, the amount of instructions he's got, what experience he knows about.
So there are some situations that you could foresee where a child engaged in play, even though not properly supervised, could nevertheless assume a risk.
Very remote.
Okay.
I'll tell you, if I were the trial judge, I would never charge a 9, 10-year-old kid for a primary assumption of the risk where a coach did something genuinely stupid and the kid got hit in the head with a ball and had no idea. He was on a ball field, what, for the fourth, fifth time in his life? No, primary assumption of risk absolutely does not apply.
Well, what about the case where two kids have a fight in the schoolyard? One kid gets hurt and sues the other kid. Was there an assumption of risk there?
By the kid who got punched or by the kid who...
By the plaintiff, the kid who, yeah. Two kids have a fight. One kid winds up with a cut lip, sues the kid who gave him the cut lip, and the answer is assumption of the risk, primary assumption of the risk. Is that a good defense?
Probably so. If two kids willingly engaged in a fight, if you get punched in the nose, I guess you have to sort of expect that to happen in a fight. But that's a
so even kids can assume the risk and can have primary assumption of the risk in some cases.
Yeah. Yes, of course. I'd say that's a very rare case. If it's like an 11-year-old kid, maybe if an 11-year-old kid in a schoolyard where there was no adequate supervision, there might not be assumption of the risk.
Well, yeah, I didn't give you the case where he's suing the gym teacher who let the kids out of his sight, but he's suing the other kid.
All right. We can talk about it. I mean, the hypothetical thing is so hypothetical that the point that I think really is we really can't take our eye off Section 1411 of our state's statutes.
So what rule would you have? Is it an age rule when primary assumption of risk under no circumstances can be asserted?
I would say before primary assumption of the risk is ever charged, that the court has to be extremely careful because Section 1411 says in any case where there's culpable conduct, Assumption of the risk does not apply.
All right, let's assume you got a court that's going to be extremely careful. What's that court going to do?
You know, it would have to follow what this court has already said. There's 3 times when it's permissible. One, and under the
Professional
Baghdad
sports.
case where there was a signed agreement not to hold the defendant liable for an injury, or 2, where there's a professional athlete who knows every single aspect of where he may get hurt in the sport and making money doing it and goes and performs it, or the 3rd area, which seems to swim
Well,
that
it
line.
must be the playground fight, because you said there was an assumption.
No, that wasn't the playground fight. But if I were the court and I was charging a jury, that's the only time they'd hear it, is when I would follow what this court has said. And I certainly wouldn't follow my beloved Second Department, because they've really gone willy-nilly. They totally ignored Section 1411. And they say basically any time, and this is what the defendant is saying here too, any time any performer engages in any activity where there's a foreseeable potential for getting badly hurt, then that's when you apply primary assumption of the risk. And I say to the court, if the court were to go along with that, Section 1411 would be turning in its grave because it's dead, and we're back to assumption of the
Well, if
risk,
it's dead,
we're
it
back
won't
to
turn.
contributory negligence. But, thank you very much,
Okay,
everybody.
thanks, counsel.
Right.
Counsel?
Thank you. Very, very briefly, I think, again, in terms of the standard to be applied to the school district here, I don't believe it's the prudent parent. I think under the circumstances of this particular case where you have summertime voluntary activities, it's the reasonable care standard.
Even then, you know, if you were to prevail on asserting primary assumption of risk, this case is not over, right? Because among the allegations here are that the banister was unsafe. And I think we've got cases that say if you're playing a sport and the competent producing cause of the injury is not an element of the sport, but a defect in the equipment or the playing field or something like that, primary assumption of risk does not apply.
We had made a motion for partial summary judgment on the issue with respect to the railing, which Judge Krogman granted and which was not appealed. So it's our opinion at this point, and we'll have to straighten this out, obviously, if Mr. Ledwith thinks differently, but it's our belief at this point that the railing and construction and design issues are out of this case, that really what we're dealing with is a negligent supervision case, not the other issues. And the appellate division did not change that. The only thing that went to the appellate division was this question with respect to the amendment. The last thing I would like to say is this, is using your example, Judge Smith, if you have the 2 kids in the playground fighting, and let's assume they're 10 years old, and let's assume that there is not a teacher immediately present. So there's an argument with respect to negligent supervision.
And so the suit is against the teacher, not one kid against the other.
That's right. So the suit is against, or the teacher and the kid, either one. So the suit is against the teacher or the school district. In that situation, I still think you do not create a decision based on the age of the participants, but on their knowledge and voluntariness with respect to their participation. And I think that's the standard that already exists, that you folks and the second and fourth and first and third departments even acknowledge with respect to the application of primary assumption of the risk. And that you do not, at the same time, I would respectfully suggest that the negligent supervision issue is the same. And if you assume the risk of being in a fight, or you assume the risk of falling off the banister, then whether your negligence claim is based on negligent supervision or on some other theory, they're equally subject to attack by primary assumption.
The problem I see with that analogy, though, is that if you got these 2 kids, it's conceivable the kid, you know, the victim, the plaintiff, the one who lost the fight, is going to say, the only reason I fought is because I was being egged on, and you know how kids are, and I was in a circle, and the teacher was nowhere around. Still primary assumption of risk?
Yes. I think so.
Okay?
Okay.
Thank you, counsel.